brilliant to have all of you here with us today. And special thanks as well to Linklaters for presenting on this really interesting topic, especially at the moment. It's all very, very new. So without further ado, Ben and Ria, can I pass over to you? And be lovely to hear what you're going to be speaking about today. And yeah, it'd be great to introduce yourselves. I should say as well, for everyone in the chat with us, if you have any questions, please do pop them into the chat there, and we'll address them at the end or throughout if we can. But otherwise, Ria and Ben, over to you. It's delightful to have you here.
Great, thanks so much, Leo, and it's an absolute pleasure to be here too. So, yeah, as Leo said, we're going to speak today about the UK's Online Safety Act. It feels, maybe to us, but maybe to everyone, that barely a day goes by when the Online Safety Act is not in the news in some way. But it's an act that is huge in its application. Ofcom themselves think it applies to over 100,000 services in the UK. It's an act that is hugely complicated. I think one former Supreme Court justice described it as a paper chase of definitions and other tricky terms. And for both of those reasons, it's an act that's often quite misunderstood or difficult to get to grips with. So the purpose of today's session is really to explain what the Online Safety Act is, how it applies to interactive entertainment, and what to think about when building your framework to comply with the Act. I'll just do quick intros to explain who Ria and I are. So my name is Ben Packer. I'm a partner at Linklaters in our litigation and investigations team. I focus on advising clients on contentious issues and ideally advising them on how to avoid those issues altogether. So I co-lead our OSA practice here at Linklaters, and we've advised a range of clients, including those in the gaming sector, on their compliance with the OSA, on their engagements with Ofcom, on threat and litigation to do with online safety issues, and a whole range of other stuff like public inquiries in this space. Ria, shall I hand over to you to do a quick intro?
Thanks, Ben. So as Ben mentioned, we have a cross-practice online safety team, which I am also a member of. My background is in digital regulation, and I work really closely with Ben on the mandates he's just mentioned for a whole range of clients, including, as Ben said, those in the gaming sector. In 2021, I was seconded to Ofcom, who are the regulator of the online safety regime in the UK and the regulator under the Online Safety Act, which we'll be talking about a lot. And at that time, Ofcom was gearing up to enforce the OSA. So that was an exciting time. And I've worked with a whole range of clients in the online safety space. So gaming, but also social media, video sharing platforms, dating sites, marketplaces, and so on. So a kind of cross-industry range of experience there.
Great, thank you, Ria. So our agenda for today, we have an hour for this session. The plan is for Ria and I to spend the first 45 minutes or so running through the 6 topics that you see on the screen. So we're going to start off looking at what is the OSA and why is it relevant to gaming. We're then going to dive into who is responsible for complying with the OSA. We're then going to look at the 2 areas of duties that apply in relation to the Online Safety Act. So we'll start with the illegal content duties, and then we'll look at the child safety duties before doing a bit of a deeper dive into age assurance. And finally, we'll finish by having a quick look at Ofcom's current priorities and what to expect in the coming months and years. That should leave us with 10 to 15 minutes at the end for questions, but we'd really encourage you to ask questions in the chat box as you go on the Zoom. Ria and I will keep an eye on those to the extent we can, and we'll try and answer questions as we go rather than leaving it all to the end. So yeah, please do give us your questions, reflections, any input, very, very welcome. So what is the Online Safety Act, and how does it apply to gaming? So as people will be aware, the aim of the Online Safety Act, the very ambitious aim of the Online Safety Act, is to make the UK the safest place in the world to go online. And it does this by imposing a set of duties on what are called regulated service providers. And those duties require them to identify, reduce, and manage the risk of harms from those 2 types of content I just mentioned. So illegal content and content that's harmful to children. The OSA itself passed in late 2023 after a very long gestation period as it made its way through Parliament. But it's only actually this year in 2025 when the main duties of the Act have really started to bite, and where Ofcom is now really starting to ramp up analysing compliance and considering enforcement. So as you can see, the main part of the Act imposes duties on regulated service providers, and the natural next question then is, well, who are regulated service providers? And there's 3 types of service that are within the scope of the Act: user-to-user services, search services, and pornography services. For today's purposes, we're going to focus in on user-to-user services, as that's most likely to be relevant to gaming clients. So we put out on the slide the rather wordy definition from the Online Safety Act of what a user-to-user service is, but it is important to look at because it does explain what is within and outside of the scope of the Act. So user-to-user services means an internet service, and by that simply means a service made available by the internet, by means of which content is defined incredibly broadly to mean virtually anything a user generates, so not just written messages, photographs, and videos, but it also covers data of any description, so that could cover things like in-game assets. So user-to-user service means an internet service by means of which content that is generated directly on that service by a user, and a user means an individual in the UK or an entity incorporated in the UK, and it's completely irrelevant for the purpose of the Online Safety Act whether they're registered or logged in or not. But the definition carries on to say services by which content which is generated by users or uploaded or shared by users may be encountered by other users. And encountered, again, is a really broad definition to mean read, view, hear, or otherwise experience the content. So Ria's going to return to this into a second to explain how Ofcom have applied that definition in the context of gaming. But as you can tell, it is incredibly broad and can capture a whole range of online gaming services. It is worth noting, though, that there are further criteria to be regulated in the Online Safety Act. So first of all, the user-to-user service has to have links to the UK to be covered by the Act. And by this, Ofcom means one of 3 things. They mean either a significant number of UK users, that UK users are one of the target markets for the service, or that the service is capable of being used by UK users, and there's grounds to believe that it poses a risk of harm to UK users. There are also certain exemptions in the Act, which we won't go into today, but for instance, certain review services, other types of services are exempted from complying by the Act due to Schedule 1. So that's the background. I'm now going to hand over to Ria to go through in a bit more detail how those definitions apply to gaming services.
Thanks, Ben. So I think the slide, oh great, the slide's loaded. Ofcom have described in their guidance gaming services, and this is not a definition that's in the law, but they talk about gaming services as services that allow users to interact within partially or fully simulated virtual environments. You can already see some statistics on the screen, and these are all taken from research Ofcom has done for the risk assessment it has to do of the whole industry of regulated services, which it calls the Register of Risks. So you can see from Ofcom's research, firstly focusing on children in the gaming space, Ofcom has found that 75% of children who were surveyed, aged between 8 and 17, were involved in some kind of online gaming. 25% of those play with strangers, and of those, most of them, 24%, chat in-game with strangers, and 62% of the parents who were surveyed were concerned about their children's ability to contact strangers online in gaming. Ofcom also noted that the proportion of children gaming from age 3 was increasing. The other issue that Ofcom is concerned about is illegal content on online services. And so one study they looked at showed that 41% of perpetrators who were seeking child sexual abuse material on the dark web had sought contact with children had actually done so via online gaming. They also found that 83% of adult gamers who were surveyed had experienced harassment while online gaming. So these stats show why online safety is important in a gaming context and why it's one of the service areas that Ofcom is interested in. As Ben noted, the Online Safety Act only applies to user-to-user content. So in a gaming context, What that means is that provider content in a game is not regulated under the Online Safety Act, although it will be regulated under other laws. As an example, if there was violent content in a game created by the provider, like finishing moves, that's not regulated under the Online Safety Act. But any typed messages which players exchange, which could be about those finishing moves, about the strategy, or about anything else really within that gaming environment, are regulated under the Act. Then we've just noted some of the features that Ofcom has identified as potentially increasing the risk of illegal or harmful content that could be relevant in the gaming space. So they've noted chat functions, which can either be one-to-one or wider group chats and beyond. User-generated content sharing, so that includes both user-created games and modding, virtual and augmented reality spaces, and games with built-in social features. Ofcom is particularly concerned about user profiles because those can reveal information about the user, perhaps their age, their sexuality, their race. And profiles can also, in some circumstances, say Ofcom, be used to allow coded content, which could be harmful content, to be disseminated. Ofcom also focuses on the risks presented by the ability to make in-game purchases or do gifting. For example, in-game marketplaces where skins can be traded. In October, so just last month, Ofcom published a blog post on the OSA in gaming, which you can see on the screen. This pop-up is what they shared on LinkedIn to flag the post. So this could be a good time for the gaming industry to consider their OSA compliance and whether it's up to date. On that note, I just briefly want to mention the sanctioning power that Ofcom has under the OSA. So Ofcom ultimately has the power under this law to impose fines of £18 million or 10% of a provider's annual global turnover, whichever is greater. They can also require providers to make changes that would make their service safer. And in really extreme cases, they could even require that internet service providers block particular services from being used by UK users. So the ultimate sanctioning powers are pretty severe there.
Great, thanks Ria. And on that note, that explains why it's important to be absolutely clear on who is responsible for complying with the OSA. So we thought it was worth doing a bit of a dive into this topic because evidently within the gaming space, there's going to be various different actors along the chain that are responsible for different aspects of the user's experience. And if we just flick over to the next slide, the OSA actually, unusually for the OSA, is quite straightforward in explaining who is responsible for complying with the duties in the Act, and that is that those obligations rest on what's called the provider. And that's defined in section 226 to mean the entity that has control over who can use the user-to-user part of that service, and that entity alone. So it seems to rule out the possibility of there being multiple providers who are each responsible. It seems to suggest the entity that decides who has control over access and use of that part of the service, they are the ones who must comply with the Act. That's obviously going to be a fact-dependent question in each case. It may depend on the particular setup of the gaming system and the various online functions that come with it. And on that, I might hand over to Ria to give a bit more colour on that topic.
Sure, thanks. So as Ben mentioned, we know this is a topic of interest, and because it's fact dependent, I suppose there can be some confusion. Ben said it's a simple definition, and it is, but that doesn't necessarily mean it's easy to figure out in practice actually what that means always. So I thought I would just talk through some examples. So a game store would be responsible for the user-to-user features where it's the provider of them. For example, that would include if a game store has its own chat functionality. And it would need to ensure, therefore, that that user-to-user feature, the chat functionality, complies with the Online Safety Act. And in some cases, that could include implementing age assurance, which is a topic I'll come back to, including exactly what that requires under the OSA. In practice, the game store may already hold information about users' ages and whether they're over 18, because it could have payment information, given that purchasing of games is done in the game store. So in some ways, in practice, there might already be systems and processes that some game stores would have set up in that space to understand the age of at least some of their users. In other circumstances, a game developer is responsible for OSA compliance, and that's where the game developer itself is the provider of the user-to-user feature under the law. So in this case, it might be if a game uses its own built-in chat feature that does not rely on the game store's chat functionality. In some cases, a game developer may not have any information about its users' ages, and introducing additional age verification could create a lot of friction for the user experience. So in some cases, we have seen examples of where game developers have been relying on the game store's age verification processes. Now, it's important to know that even if this is happening, if the game developer is the provider under the OSA, the game developer is ultimately liable for OSA compliance. So in particular, the game developer must be sure that if it's relying on those processes run or organized or put together by the game store, the process must be compliant with Ofcom's requirements for highly effective age assurance, which I will cover in more detail in a little bit. Thanks, Ben.
Thanks, Ria. So we've talked now about who is responsible for OSA compliance. We're now going to move on to look a bit more detail about what exactly those who are responsible have to do under the Online Safety Act. As I mentioned earlier, it is a complex piece of legislation, so there's lots of little duties and obligations around the edges, but the core duties are those really set out on this slide. And as you can see, they basically fall into three buckets. One is that by March 2025, so 6-7 months ago, any services within the scope of the OSA had to have conducted their illegal content risk assessments and then put in place measures to mitigate the risks identified. So Ria's going to come on in a bit more detail in a second to talk about what those risk assessments involve, but those are, for those who've done it, they'll know those are big exercises that require you to assess many different categories of illegal content, work out the possibility of that content or behavior occurring on your platform, and then put in place measures to mitigate those risks. So that was due by the 17th of March, 2025. The next set of duty then relates to the children's part of the Online Safety Act. So by the 16th of April, 2025, all in-scope services had to conduct a children's access assessment. And again, we'll go through what this is in a second, but it's essentially working out whether children can theoretically access your user-to-user service. And if the answer to that is yes, then you must go on to complete the third set of duties, which is the children's risk assessment and children's safety duties. So that was due by the 25th of July, 2025. And again, we're going to come back to look at a bit more detail about what that risk assessment required and what those duties required later. I think it is worth noting, though, that Ofcom realised that the obligations they were imposing, or the Online Safety Act was imposing on the entire industry, were hugely burdensome. And so there was a realism that not everyone would be fully compliant by those deadlines. So if you look at some of the guidance and statements Ofcom put out at the time, they did recognise that within the first 6 months of each of these duties coming into effect, they understood people would not be fully compliant from day one and would need some time to put measures in place. That said, they have made it very clear that for the risk assessments and the access assessments, they did expect those to be done by the deadline. And equally, they've also made it clear that they won't hesitate to enforce against what they call deliberate or egregious breaches, which pose a significant risk of harm to UK users, especially children. So we'll speak a little bit later about Ofcom's enforcement work to date. But for now, they've shown some acceptance that it's going to take time for people to get compliance, but that time is fast running out. Over to you, Ria, to talk a bit more about the legal content risk assessments.
Thanks, Ben. So I'm going to try and put some colour around exactly what OSA compliance looks like in terms of performing those risk assessments that Ben mentioned. I do just want to make it very, very clear in the outset that the slides that look like this and set out types of harm and then sort of functionalities and how the harm arises, all of this is based on what Ofcom thinks. So all of this summary is what Ofcom thinks is harmful, what Ofcom thinks happens in gaming, which is obviously important because they are the regulator. But there might be people out there thinking, well, I have that functionality and there's none of that happening on my service. And I'm sure in some cases that's true, but this is Ofcom's perspective. So this is a whistle-stop tour of the illegal content risk assessment. And basically that sets out different harms which Ofcom says provide, different types of harm that Ofcom says providers need to assess separately. You need to look at each type of harm and how it can arise on your site based on the features and functionalities that Ofcom has identified, and then give each type of harm a risk level, high, medium, low, or negligible, based on that evidence. So we're going to focus on the harms that Ofcom has called out as a risk in the context of gaming services, and those are the ones that are highlighted in yellow on the slide. You can see at the bottom there are the other harms that you do also have to assess, but Ofcom hasn't given us many examples of those in context of gaming. So the first is terrorism. Ofcom notes that in their research, gaming has been used as a space for recruitment or training by extremists for terrorist activities, and games can also promote the use of violence against a state or political figure, and the nuance of that Ofcom thinks may not be caught by moderation, because often the language on its face without kind of all of the context is not going to necessarily breach someone's content moderation or terms. The next one is child sexual exploitation and abuse. Perpetrators can engage, unfortunately, with children via gaming. So there's a general risk there, but a particular risk for grooming of children. And as we mentioned, there are opportunities for strangers to have contact with children. In some cases, relationships can be developed, trust can be built. And users are also often anonymous, so they can hide their real identity, their motivations. Communication with strangers is normalized, and trading and gifting can also be common, which can be used as a coercion tactic for those perpetrators. Hate is one of the other harms that Ofcom calls out. There was a UN report that described that hate can flourish on certain gaming platforms, and that racism or homophobia can be normalized in in-game chats and streams, which can contribute to that kind of content. Equally, harassment, stalking, threats, and abuse have been called out in certain studies. And some studies have found that normalized harassment can be part of the culture of some games, particularly for female gamers who were said to experience misogynist attitude in some gaming spaces. There are risks relating to human trafficking, including of children who can be recruited using gaming credits. And there's also a risk in relation to offences that relate to proceeds of crime, because money mules can recruit via online gaming services to find people who will move money around and help launder money. And children can also be groomed into illegal activities like money laundering via gaming, again, because of those relationships being built up and the potential for coercion tactics that we discussed. On the right-hand side, you can see that Ofcom has called out specific functionalities to consider, which it considers are likely to increase the risk of illegal content on user-to-user services. And again, we've noted the ones that Ofcom says are particularly relevant in context of gaming. So they talk about direct and group messaging, as we've already mentioned. Communication with strangers can be normalized, excuse me, and this can make children vulnerable to possible grooming. Anonymous user profiles, whereby perpetrators can hide their identity and age or pretend to be, for example, a child talking to another child. And anonymity has also been shown to embolden users. So people will say things anonymously online that they wouldn't say to people's faces, which can exacerbate harms like hate or abuse. as mentioned, in-game purchases can be used to groom not just children, but also vulnerable adult users and build their trust. And that can be used as a recruitment tactic for trafficking or to coerce people into sending sexual images or messages. Ofcom also focus on live streaming and how users might reveal their identifying characteristics live and the issues of kind of moderating live streaming. Obviously, it's happening in real time, so it can be difficult. And Ofcom has also commented that the nature of certain gaming communities, given that insulting can be commonplace in chats, particularly where adrenaline is high or everyone's trying to achieve a shared goal, or conversely trying to, I suppose, beat one another, that can increase the risk of hateful or abusive content. Jen, if you just, thank you. So having conducted the risk assessment, service providers need to implement the relevant safety measures, which can either be from Ofcom's codes of practice, where they recommend certain measures, or they can be equivalent measures that you can demonstrate are equally effective. And providers also need to keep both the risk assessments and the corresponding measures up to date, which means refreshing them at least every 12 months. And if a significant change is made to the service or new products or services are rolled out, and also if Ofcom makes certain changes to the risk profiles in its guidance. And if providers are taking those steps to do the risk assessments, implement the safety measures and keep them up to date, then Ofcom considers that service has implemented a safety by design approach. Back to you, Ben.
Great, thanks, Ria. Before we move off illegal content risk assessments of illegal content duties, it's probably worth just saying that Ofcom's expectation is not that you will assess these risks and put in place to mitigate them down to zero. They do accept that that is essentially an impossible ask, but the expectation is that you will do the assessment and then you'll put in place sufficient measures to be compliant with the illegal content duties. And it's going to be the same story when we look at the children's duties now too. But just important to note that it's not a regime that expects there to be zero harmful or illegal content ever. So Ria's honed in there on the illegal content risk assessments and duties. We're now going to turn to the other big part of the Act, which is the children's duties. I should say, I've just checked, we've had no questions so far on the chat. So please, just a reminder that if you have any questions as you go, please do pop them in there and we'll try and pick them up as we get through it. So as I mentioned earlier, by April of this year, all in-scope services were supposed to have assessed whether children could access their service. And that is a two-stage test that we've set out on this slide. So the first stage of the test is to ask whether it's possible for children to normally access the service. The slight kicker there is that you can only conclude that the answer to that question is no if you have what Ofcom call highly effective age assurance in place. And Ria will come back to that later on, but the sort of TLDR on that is that highly effective age assurance is a very high threshold. It's not just self-declaration of age, it's using other measures to accurately ascertain what someone's age is. So most services are probably unlikely to be able to conclude at stage one that children are unable to access the service, and therefore they'll jump to stage two here and have to consider two different criteria. First of all, are there a significant number of children who use the service? Again, unless a service has highly effective age assurance in place, it may be difficult for providers to reliably work out if there are a significant number of children using the service. So for that reason, Ofcom has suggested that services focus on the second criterion, which is essentially asking, is the service of a kind that is likely to attract a significant number of children? And on that, Ofcom has said the things to consider here are whether the service benefits children. So does it provide them with entertainment, education, or some kind of support? Does it have content or a design that appeals to children? Or do children form part of the service's commercial strategy? So for example, if ads are targeted on children, at children. It's probably worth noting at this stage, by children, we mean anyone under the age of 18. That's a defined term in the Act. So by April, services are expected to have done this assessment and record the outcome of that. And Ria's now going to essentially look into what happens if you answer yes to this, that yes, it is possible for children to access it, and yes, it is likely to attract a significant number of children. because then you have to conduct a children's risk assessment. So back over to you, Ria.
Thanks, Ben. Again, I just want to mention that the content on this slide is very much according to Ofcom, where Ofcom see the harms and Ofcom see the issues with, or the risks of potential features. And the other point to note just before I start the rundown, as Ben helpfully mentioned, that you don't need to get the risk down to zero. This law looks at the risk arising on services based on the systems and processes they have in place. And Ofcom have said they will not consider individual pieces of content. So if a service is doing everything right and somehow a single piece of offending content gets onto the site, that does not automatically mean the service is not compliant, but it's about demonstrating that the processes were followed in the appropriate way and that relevant systems are in place. So then turning to this slide to focus on what you have to do under the children's risk assessment, again focusing on the harms that Ofcom has called out as particularly relevant to gaming services, which you can see are highlighted in yellow. And under the law in relation to children's assessments, you have to consider content that's harmful to children, firstly primary priority content and then priority content, and then there is a category of non-designated content as well, but we'll just look at the first two for this purpose. So the first piece of primary priority content to consider in context of children is pornographic content, which is both shared on gaming sites and can be stumbled upon inadvertently on those sites. The second one is content which encourages or promotes instructions for suicide and self-harm, where this doesn't reach the threshold of illegality. So in some cases, this can be shared unprompted in gaming sites, and unfortunately, children can also be targeted and drawn into deliberate conversation in relation to suicide and self-harm. Then the priority content that's abusive or incites hatred on the basis of race, religion, sexual orientation, disability status, etc. And this can be magnified in group chat type settings because users might egg each other on. And extremists also sometimes target gaming services to spread hateful views. Content that encourages and promotes serious violence are of concern in context of children. And violent comments sometimes circulate in chat, particularly where the games themselves are violent, although, as we mentioned, the provider content is not caught in the scope of the regulation. And then we see bullying content. So children have talked about things like disrupted play, trolling and griefing, being called offensive names. Then on the other side, we've got the specific functionalities which Ofcom considers are likely to increase the risk of content that's harmful to children in a gaming context. And Ofcom's called out content recommender systems where, for example, we've seen unintentional encounters of pornography. One gaming website recommended, the algorithm recommended pornographic content to an avatar in a study which represented a child who was age 14. Adverts on gaming can also promote pornography and allow users to encounter pornography. Messaging in-game exposes children to hateful and abusive content in some circumstances. As mentioned, user profiles are a risk for the same reasons really that we talked about in context of illegal content, the anonymity and the identifying characteristics, and the nature of gaming communities where more abusive language can be seen as commonplace or described as banter in some surveys, and also the immersive nature of gaming and the competitive nature of gaming can, in some cases, increase the likelihood of people making hateful or abusive or bullying type comments. And again, as I mentioned before, in terms of safety by design, the requirement is that users will conduct their risk assessments, implement corresponding safety measures, and keep the risk assessments up to date.
Great, thanks, Ria. We've had a great question in, but I'm going to come to it just after we've gone through the last 2 slides on the children's duties, and then we'll pick up the question because I think it's a really good one. So when you've gone through the process that Ria's just outlined of looking at all the different risks on the services that are harmful content or interactions that children may encounter, how does this actually play out? What does this mean for services in practice? And really it boils down to having 3 options really for the user-to-user part of any service. And that's one is to have an 18s only service. So that is to put in place highly effective age assurance so you're confident that everyone who is accessing that service is over 18 and you don't actually need to think any further about the risks that Ria has talked about. That then means that any content that is legal can be on the platform and you don't need to worry about having measures in place to identify and remove self-harm content or suicide content or the other types of content Ria's talked about that are legal but which are harmful to children. So that's option number 1. At the other end of the spectrum, we go over to the far right of the slide first. The other option is to go completely the other way and make the entire service child safe. So that would be making sure that all content that can be encountered on the service is safe for children. So that means no suicide content, no self-harm content, no pornography, none of the other types of content that Ria's just talked through. If you do that, that needs to be explained in the terms of service, and there needs to be really effective content moderation and reporting procedures in place to make sure that if any of this content does attempt to be uploaded to the service, it's swiftly dealt with. And then I guess the middle option is a kind of halfway house between the two, which is a kind of default experience that's safe for all ages, but then a segregated area where content that over 18s are able to interact with can include things like self-harm content and suicide content, but the sort of broader user experience, it doesn't allow that sort of interaction. So you have those 3 kind of options available to you. Ria, shall I hand over to you to talk about what we mean by highly effective age assurance?
Yeah, absolutely. Thank you. So I think we need, yeah, thank you. I think we need that slide. So yeah, we've kind of mentioned highly effective age assurance a few times. Ofcom is quite prescriptive in their guidance about what they mean by highly effective age assurance, and they've given this non-exhaustive list of criteria that they can, or of methods, I should say, that they consider can be highly effective. So you can see on the slide, open banking, photo ID, facial age estimation, MNO age checks, credit cards, digital identity, email-based age estimation, and that's based on other ways that the email has been used. For example, if someone's exchanging emails with their mortgage company or similar. And they comment specifically that self-declaration of age, age verification through payment methods like solo or debit, which don't require the user to be 18, or general contractual restrictions in the terms of service, which say things like you must be 18 to use this site, will not be sufficient for their highly effective age assurance. So in the gaming space, we have seen some game stores requiring credit card checks already in order to access things like mature game content and the community hubs associated with them. We've also seen people requiring government-issued IDs, facial age estimation, or mobile network age checks. And sometimes that's done via a third party. So there's a lot of age assurance providers, Yoti's one, but there are multiple on the market. And Ofcom has said it's deliberately silent around sort of which third parties to use, because it's very aware that the technology in this space is updating all the time. Providers may change their methods. It doesn't want to prescriptively recommend somebody at the expense of somebody else. So a lot of people, providers, not just in the gaming space, but more widely in the user-to-user space, have been concerned about their customer experience in this space, the player experience and the user friction that would come from introducing age verification. And one of the methods we've seen people using, which is not on the list, but as I mentioned, the list is not exhaustive, is using behavioural indicators and AI estimation based on the user's behaviour on the site, potentially scanning profile photos, potentially looking at user engagement, content of their posts. There are various indicators that can suggest a user's age. And some providers may have this data already. For example, they might use it in their marketing strategies. We are seeing a trend of platforms doing this in the wider market, but if this method is used, it's still really important to make sure that the method can meet Ofcom's criteria. And we can see at the bottom of the slide that it needs to be technically accurate, robust, reliable, and fair. So what that means in Ofcom's context is that it can gauge someone's age or whether a user is a child or an adult to within margins which you have established within a lab environment, a testing environment, and whether it can do it in context of the real gaming service, whether the results are reproducible, and whether the results eliminate bias as far as possible. So the result, for example, any facial estimation does not work better for people of a particular gender or a particular race, because obviously that would create problematic bias for that method. It's also important to have a robust appeals procedure, and the more the age verification process relies on AI and estimation and interpretation of a user's features and behaviour to establish their age, the more important that appeals process will be, because the more margin for error there is. The final point I wanted to make on age assurance is that it is important that your age assurance is aligned with your data protection strategy. So we've talked a lot about criteria that could help you decide the age of a user, both in terms of their things that they're doing that an algorithm might assess, but also in terms of a very overt age verification process where you might say, please upload your driving license or your credit card. But in either case, you're going to be processing a lot of sensitive, potentially, or confidential or personal information about that user. So to the extent you have in place any sort of data protection, whether you have colleagues working on data protection or it's something you think about yourself, you need to make sure that this aspect, particularly of your online safety strategy, is joined up with your data protection strategy. Ben, I think back to you.
Great, thanks, Ria. So before we move on to look at Ofcom's priorities, I just want to pick up the question that's been asked in the chat, which is a great question from Joanne Sproul. And she's asked, do you foresee the pressures of compliance with the OSA significantly curtailing gamer-to-gamer interaction across platforms? And what will the cost be to smaller game developers? I think there's a few things to say about that. So first of all, when the bill, as it then was, before it became an act, was going through Parliament, there were lots of concerns raised about just how broad the act was going to be and how, unlike some other regimes around the world, there was no kind of minimum size exemption for requirements. It applied to anyone, provided they had a user-to-user service with links to the UK. And what we've seen in the aftermath of the online safety act coming in is some platforms have chosen to close down rather than comply because of the burdens of it. So the examples that Ria and I often talk about when we talk about this topic is the London Fixed Gear Forum, which is a very old, ran on quite old internet technology, but was a very old, long established internet forum for enthusiasts of fixed gear cycles, that chose to close down rather than trying to do all the risk assessments and put in place all the measures. There was another forum for, I think it was hamster enthusiasts, Ria, I want to say, it might have been guinea pigs, I think it was hamsters. And they chose to migrate the community from their own user-to-user service, their own forum board, onto, I believe it was Reddit instead, because then they could simply run it and rely on Reddit to put in place all the measures to comply. So that it has been a concern. I think what I would say is a lot of the burden of the Online Safety Act is bureaucracy. It is a lot of risk assessments and working through analysing whether theoretical risks could affect your service. It could be for services with relatively limited functionality. So if you imagine an online game where the only functionality is user-to-user chat, it might be that your risk assessments actually come out meaning you don't have a huge level of risk, and then the measures you need to put in place are also not massively burdensome or costly. But it is the burden of actually doing the bureaucracy and preparing a risk assessment. And on that note, I would say Ofcom are trying, they're obviously constrained with the Act that was given to them by Parliament. They've got to do the best they can with it. Ofcom are trying to ease the burden on smaller providers. So they've come up with a set of online templates and online tools to help you assess, A, are you in the scope of the Act? And B, if you are, how can we help you put together your risk assessments? They've got some really quite good tools that you can use on that. They've also done quite a lot of industry engagements. So they did seminars earlier this year to try and talk through how smaller services can comply. So there are materials out there, but I completely see the concern. It is an extra level of burden, and it is one that I think, potentially is proportionate for the very biggest of platforms that rely on user content for their revenue. It feels like a lot for those where user-to-user interaction is just a side feature to the main product. Ria, is there anything you wanted to add on that before I move on?
No, I think you've covered it. Thanks, Ben.
Perfect. So we're going to spend a bit of time now looking at Ofcom's priorities as they go ahead. So we mentioned earlier that Ofcom themselves estimate over 100,000 services are within the scope of the Online Safety Act. They've made it clear that they don't have any chance really of assessing whether every single one of those is compliant with the Act, and therefore they're going to prioritise looking at the platforms that pose the greatest risk of harm and reach the greatest number of users. And in that vein, we wanted to just pick up on some of the themes that are coming through in Ofcom's work at the moment. One of the main ones to notice is that Ofcom have now announced an enforcement program aimed at platforms which are popular with children. And in this regard, they've named 5 platforms in particular, being TikTok, Snap, Instagram, X, and Roblox. So you have got a gaming platform in there. They've said they've been asking those platforms to provide information on how their algorithms match for children's safety duties, and then they'll be looking into this actively over the winter. So it's already clear that Ofcom are starting to focus on those platforms who have lots of child users. And one of the features of Ofcom's enforcement work is that it's very public. So we will know even when they open any investigations in that regard because they announce it all on their website. So that's one area to watch. I think the second thing we wanted to highlight, though, is that to date, Ofcom's enforcement work has been very much focused on the kind of platforms who haven't really done anything to comply with the Online Safety Act and who pose massive risks. They've focused mainly on messaging boards who their main focus is spreading content that's harmful to children. So they've given an example of a very well-known suicide forum, which contains material that's very harmful to children. So they've focused on platforms like that. They focused on file sharing websites because they've identified file sharing websites as posing a big risk for the sharing of CSAM. And then they focused on those platforms who simply haven't engaged with Ofcom at all when asked. So they've sent out information notices to several platforms asking for their risk assessments, and they've refused to comply. So for now, Ofcom's gone for that sort of low-hanging fruit, but as I mentioned before, they're now starting to move beyond that and look at platforms for popular children. The other thing that we just want to note, though, is the second point here about event-driven enforcement, and that is, like all regulators, Ofcom is bound to switch its enforcement focus as the real world changes, as real world events unfold. So the reason we wanted to flag that is that for now, whilst gaming has perhaps not been top of Ofcom's agenda, it is the sort of area where, should there be something high profile that happens that implicates a gaming service, you could see Ofcom quite quickly moving to start examining compliance in this sector in more detail. So that's just one thing to bear in mind too. The other thing to bear in mind is that Ofcom are focusing more and more on the protection of women and girls. So they've published draft measures earlier this year about additional measures firms should take to protect women and girls, and they're expecting to release final guidance by the end of this year. So again, that's an area to watch because that's going to become ever more of a focus for Ofcom. And then finally, I was just going to mention before we wrap up for any further questions, 4 further themes. One is that Ofcom, as well as the duties we've already talked about, there's an extra tier of obligations in the Online Safety Act for the biggest platforms, and they'll be called categorized services. And Ofcom is currently going through the process of working out which services will be categorized, and then they'll be publishing a register. That's already overdue. That was meant to have been done by the summer, but Ofcom have been delayed by legal challenges to their work in that space. The reason I mention it is because there are gaming platforms who may well be categorized and therefore be subject to the additional duties. So that maybe you're categorized as a category 1 service because you are a user-to-user service with a sufficient number of users and sufficient functionality that meets that criteria. Or maybe that some services are category 2B, which is a categorization for messaging services that have over a particular number of users. The good news for those of you on the call who are hearing this all afresh now is that if you haven't already been contacted by Ofcom, you're probably not going to be categorized because they've been engaging with those who are likely to be categorized for several months now. But just to flag that is something that is coming to, is those additional duties for categorized services. Final few things to know. AI is a really interesting one. I could spend a whole hour talking about this, but what you can tell from reading the Online Safety Act is it was an act of its time. It was kind of drafted primarily before the sort of breakout moment for Gen AI in 2022 with the release of ChatGPT. So AI is not a particularly neat fit into the act. But what Ofcom have made very clear is that AI generated content is still content. So if users are sharing AI generated content on your service, that still falls within the scope of the act. But equally, there might be AI tools that turn out to be regulated. So it could be AI tools that allow one user to interact with another user. So for example, creating text, videos, images, or other content, maybe even in-game content that other users can instantly access. That will be regulated in the Online Safety Act. Equally, AI services that allow you to search the internet may be regulated search services. And we haven't spent much time today on search services, but that is another category of service regulated by the Act. So AI tools is another tricky area which Ofcom are grappling with at the moment. Final things to mention, if the Online Safety Act wasn't already complicated enough, the Online Safety Act has within it the provision to extend it to go even further, so to go beyond user-to-user search and porn, and also to apply to app stores too. So Ofcom have just this week kicked off a program of work to gather evidence on how app stores are involved in children ultimately being exposed to harmful content. So they've issued a public call for evidence. We also understand they're issuing information notices to app stores. And the aim of all of that is to produce a report by January 2027 about that topic. And then potentially on the back of that, the government could move to make the Online Safety Act apply to app stores too. So that's another area to watch. And then the final thing I'll just mention briefly before we open up for any further questions is fees. As you can imagine, with the Online Safety Act being as enormous as it is, and with Ofcom doing as much as they're doing, it comes with a big number. So Ofcom, I think to date, have spent over 200 million getting ready to enforce the Online Safety Act. That amount is actually going to be paid by regulated services. So Ofcom are currently going through the steps now to issue the various bits of regulations and guidance and statements to put in place a fee charging regime where they will recover the fees of administering the Online Safety Act from regulated services. There's good news and bad news on that front, depending on whether you're a big or small service. So if you're a small service, it's good news. Like Ofcom's current approach is planning to essentially put most of the burden of the fees on the biggest providers. In fact, the current proposal that they're working to would see the vast majority of their fees paid by just 5 providers, which is quite remarkable, really. And it will actually exempt lots of small and medium enterprises from the obligation to pay any fees. So that's good news for small services. I guess on the flip side, if you're listening to this and you're a big service, there's a danger that if your revenue comes above the threshold, you will also be required to pay fees to be regulated by Ofcom. So if you haven't already and you fear that you may fall within that threshold, it's worth engaging on the fees topic because that's something that is working its way through the various steps now. And will be settled soon enough. So yeah, if your global revenue is above sort of 250 million, that's definitely something you want to be thinking about. So that's a quick whistle-stop tour through Ofcom's latest priorities. I'm just going to have a quick look to see if we've got any further questions or... Ria, I think there's one for you here because it mentions GDPR.
Yeah, so thanks, Ben. I can just take a couple of minutes. So I know there was a question about age verification and how it was compatible with GDPR. And I did obviously touch on that very briefly when I was talking about it. But my background is actually in privacy prior to doing online safety work. Obviously, online safety has only been around for the last however many years. So prior to that, I was a data protection specialist. It's a complicated question. It's absolutely one that you're right to be aware of. It will be very fact specific. I imagine businesses will be looking at issues like whether they can rely on a basis for processing that relates to compliance with legal obligations, whether they think the data that they're processing is sensitive depending on the age verification method that they're using, and therefore whether that information has been manifestly made public. I think that some of the really important things to bear in mind where companies or providers are doing their own age verification rather than using a third party provider will be thinking about issues like retention, how long are you keeping that data, and security, how are you keeping that data safe, and really just thinking about what's proportionate based on the nature of that data. We have, I mentioned that a robust appeals process is important, but we have already seen in the press examples where the data relating to appeals, users were saying, I should be treated, I am an adult, but I've been boxed as a child. Here is my government ID to prove my age or similar. And those government issued IDs in this one case were actually part of a data breach. So I think you're absolutely right to be aware of it. I think the nuance of how it's compatible will be very fact specific. But I think there are, all of the key issues in the privacy space absolutely are engaged in this kind of question. And I think there is space for compatibility, but it is something to think about very carefully.
And Ria, it's probably worth saying on that topic, isn't it, that what we've seen across some sectors, in particularly pornography, is that rather than doing the age verification themselves, it's often been outsourced to kind of trusted safety tech providers like the likes of Yoti and others. In fact, I think Ofcom themselves said that all of the major top 10 most visited porn websites in the UK are now using outsource age assurance. So it's something where, providers don't necessarily need to take on that risk themselves. I know they obviously have to comply with the Online Safety Act, but in terms of actually complying with the GDPR and making sure that data is handled correctly and that you're not ending up storing lots of sensitive data and having to think about data minimization or those other obligations, it is something where outsourcing seems to be the way lots of platforms are going.
I think that's right, Ben. I think you've got the risk, but not necessarily the burdens of creating the burden of creating the structures and so on, because there are those third-party providers.
Yeah.
Tremendous. Well, thank you so much, Ben and Ria. I think this has been really, really quite an in-depth look at everything. So thank you for sort of displaying everything so clearly and talking us through it. I wondered, from sort of my perspective, I mean, you mentioned a number of sort of different types of harm and safety measures there. I mean, are these sort of fixed, or can they shift? Can they change? I mean, you mentioned sort of Ofcom's sort of shifting sort of perspectives on these things. How much change are we likely to see, do you think?
So I think that the bad news is probably quite a lot of change, and probably mainly in the direction of making this more burdensome. I'm sorry, I know on the chat people are picking up, but it seems to be there's lots of bad news on this webinar. But yeah, we've already seen in recent weeks the government has upgraded several types of illegal content to priority illegal content. So now you'll have to do risk assessments for those. As I mentioned earlier, you've got things like Ofcom consulting on measures to protect women and girls. So that's going to add another layer of obligations. And then right now there are several different parliamentary inquiries and public inquiries, all of which are considering whether the Online Safety Act goes far enough. So I think, unfortunately, the trend is probably only ever going to be to get more burdensome rather than less, or at least in the near future.
It's something to look forward to then, maybe. Well, again, thank you so much, Ben, and Ria too. It's been really, really good having you here as part of our week of insights into games.